from courtroom to living room. Picture this: California, the testing ground for America's harshest gun laws. For decades, politicians in Sacramento have stacked restriction upon restriction. 1 gun a month rules, 10-round magazine limits, waiting periods, bans on scary-looking rifles. And every time these laws got challenged, the Ninth Circuit Court of Appeals, infamous for its hostility to the Second Amendment, gave the same answer: no. Denied. Rights don't apply here. For 134 years, gun owners called it the graveyard of the Second Amendment. Not once in its history had the Ninth Circuit struck down a gun law on 2A grounds. Not once. Until now. In Duncan versus Bonta, a case challenging California's magazine ban, the Ninth Circuit just issued a mandate, the first of its kind, siding with gun owners and declaring that California's 10-round limit violates the Constitution. This isn't just a procedural win, it's a legal earthquake with the potential to collapse every magazine ban in America. And just days after that decision, news broke out of Houston, Texas. A homeowner shot and killed 2 armed men in ski masks and bulletproof vests who were impersonating police officers during a home invasion. That case, as shocking as it is, shows the reality. The Second Amendment isn't just about rights in theory, it's about survival in practice. What happens in the courtroom defines what happens at your door. And tonight we're going to connect these 2 stories: the legal fight to restore rights and the life or death moments where those rights matter most. Chapter 1: The Legal Battlefield. Duncan vs. Bonta's origins. The fight over magazine bans didn't start yesterday. It began in 2000, when California lawmakers enacted a sweeping restriction on so-called large-capacity magazines, defined as anything over 10 rounds. Overnight, millions of law-abiding gun owners were turned into potential criminals. For those who had legally purchased magazines before the ban, the law allowed possession, but banned all future sales, manufacturing, or importation. Fast forward to 2016. Voters doubled down, passing Proposition 63, which not only reinforced the 10-round limit, but also banned possession outright. No grandfathering, no exceptions. If you owned a 15-round Glock magazine or a 30-round AR magazine that was perfectly legal when you bought it, you now had to turn it in, modify it, or face criminal charges. Enter Virginia Duncan, a law-abiding California gun owner. She and the California Rifle and Pistol Association filed suit against then-Attorney General Xavier Becerra, later continued under AG Rob Bonta. Their argument was straightforward. The magazine ban violated the Second Amendment. You cannot ban arms in common use by millions of Americans for lawful purposes like self-defense. That case landed in the courtroom of Judge Roger Benitez, a federal judge in San Diego known among gun owners as Sant Benitez, for his no-nonsense approach to constitutional analysis. In 2019, Judge Benitez struck down the ban in a sweeping opinion. He wrote, "Individual liberty and freedom are not outmoded concepts. The ban on magazines holding more than 10 rounds violates the Second Amendment." For a single week, known among California gun owners as Freedom Week, the state could not enforce its magazine ban. In those 7 days, hundreds of thousands, if not millions, of standard capacity magazines flowed into California. Gun owners lined up at shops, ordered online, and stocked up legally for the first time in decades. But of course, the Ninth Circuit stepped in, stayed the ruling, and set the stage for years of appeals. Chapter 2: The Bruen Shift. Why the test changed everything. For decades, courts across the country had applied what's called a 2-step test to Second Amendment cases. First, does the law burden conduct protected by the Second Amendment? And second, does the government's interest outweigh that burden? This gave states enormous leeway to claim public safety as justification. That all changed in 2022 when the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. In a 6-3 ruling, the court scrapped the 2-step test and replaced it with a much stricter standard, the text, history, and tradition test. Here's what that means. If the plain text of the Second Amendment covers the conduct, the presumption is that it's protected. The burden shifts to the government to show that the regulation is consistent with the nation's historical tradition of firearm regulation. If no such historical analog exists, the law is unconstitutional. No more public safety balancing. No more intermediate scrutiny. The Second Amendment is to be treated as a real right, not a second-class one. That ruling breathed new life into Duncan versus Bonta. Suddenly, California had to prove that restricting magazines to 10 rounds had a deep historical tradition in American law. Spoiler alert, it doesn't. In fact, repeating firearms with capacities greater than 10 have existed since the 1800s. The Spencer rifle, the Henry repeating rifle, even early revolvers. None were restricted because of capacity. Armed with Bruen, the plaintiffs pressed forward, and Judge Benitez reaffirmed his original decision, striking down the ban once again. Chapter 3. The Ninth Circuit Mandate. Why it's different this time. Here's where history was made. For decades, the Ninth Circuit has been the graveyard of Second Amendment litigation. Gun owners might win at the district court level, sometimes even at the 3-judge panel stage. But when the case went en banc to the full Ninth Circuit, the ruling was almost always reversed. But on August 14th, 2025, something unprecedented happened. The Ninth Circuit issued a formal mandate in Duncan versus Bonta. This wasn't a temporary win. This wasn't a panel ruling waiting to be overturned. It was a final judgment that cannot be appealed further within the Ninth Circuit. The mandate made Benitez's ruling the law of the land in California. The 10-round magazine ban is unconstitutional. Period. For the first time in its 134-year history, the Ninth Circuit had struck down a gun control law on Second Amendment grounds. That's why legal experts are calling this ruling historic. Not just because of what it means for California, but because of the precedent it sets for every state with similar bans. Chapter 4. From Courtrooms to Living Rooms. Why magazines matter? Let's get practical. Why do magazines matter so much? Why fight for the right to own something larger than 10 rounds? Here's why. Self-defense isn't predictable. Imagine facing multiple attackers. FBI statistics show that the majority of home invasions involve more than one suspect. Imagine defending yourself during a carjacking where reloading could mean the difference between life and death. Imagine being elderly or disabled. A forced reload under stress is not just inconvenient, it may be impossible. There are documented cases of homeowners who ran out of ammunition during defensive shootings because of restrictive capacity limits. In one case in New York, a homeowner with a 10-round magazine fired all 10 shots when 3 intruders broke in. He was shot during his reload. In another, a woman used her husband's AR-15 with a standard capacity magazine to defend against multiple armed men, and survived. The reality is this: criminals don't follow magazine bans. They use whatever they want. Limiting law-abiding citizens to 10 rounds doesn't make anyone safer. It just makes the defender weaker. This is why Duncan v. Bonta matters. It's not about needing more than 10 rounds every time. It's about having the option when the unthinkable happens. Chapter 5. HPD case, Houston homeowner versus fake police. And that brings us to Houston, Texas. Just days after the Duncan mandate, a chilling story hit the headlines. According to the Houston Police Department, a homeowner shot and killed 2 armed men wearing ski masks and bulletproof vests, who tried to force their way into his home while claiming to be police. Neighbors reported hearing loud banging and voices shouting, "Police, open up!" But something was off. No marked patrol cars, no proper identification. Just armed men in masks trying to intimidate their way inside. The homeowner, recognizing the danger, opened fire. Both intruders were killed on the scene. Police later confirmed the men were not law enforcement. They were imposters, criminals using intimidation and disguise to stage a home invasion. Think about that. 2 armed men, pretending to be police, wearing protective gear, attempting to breach a home. Would a 10-round limit have been enough? What if there were 3 or 4? What if the criminals had backup outside? These are not theoretical questions, they're real scenarios. And they show exactly why capacity restrictions are not just unconstitutional but dangerous. the Duncan case may be a legal battle, but the Houston case shows the stakes in real life. Your rights are not just lines in a law book, they are the tools that keep you alive when evil shows up at your door. Chapter 6: California's Relentless Pushback. If you think California took the Duncan versus Bonta mandate as the final word, think again. Sacramento lawmakers have a track record. When they lose in court, they don't admit defeat. They just rewrite the rules. Take the 1 in 30 law. After it was struck down in Nguyen versus Bonta, legislators came back with AB 1078, trying to ration gun purchases at 3 per month instead of 1. Same logic, same control, just dressed up in different numbers. And they're already doing the same thing with magazines. Behind closed doors, lawmakers and gun control groups are floating new safety regulations that would limit where and how standard capacity magazines could be stored, transported, or carried. It's the oldest trick in the book. If you can't ban ownership outright, you bury people in so many rules that exercising the right becomes impossible. But here's the thing. Every time California doubles down, it creates another lawsuit. And every lawsuit now operates under the Bruen framework, which makes it harder than ever for these restrictions to survive. For Californians, the fight is far from over. But with Duncan on the books, the state is playing defense, not offense, for the first time in decades. Chapter 7: National Impact. States with mag bans on the brink. California may be ground zero, but it's not alone. Right now, at least 8 states plus Washington, D.C. have their own versions of magazine bans. New York, New Jersey, Connecticut, Massachusetts, Hawaii, Vermont, Maryland, Washington State. Each of these states imposes limits ranging from 10 to 15 rounds, and each of them just watched the Ninth Circuit, the most anti-gun circuit in the country, declare such bans unconstitutional. That precedent doesn't automatically strike down their laws, but it gives attorneys in those states a constitutional battering ram. Already, new lawsuits are being filed in New Jersey and Washington, using Duncan as a direct reference. And here's where things get interesting. Once multiple circuits start ruling in favor of gun owners, it becomes harder for the Supreme Court to ignore. We could be looking at a future case where SCOTUS finally decides once and for all whether any state can ban standard capacity magazines. If that happens, Duncan won't just be a California case, it will be the blueprint for ending magazine bans nationwide. Chapter 8: Political Earthquake. Why this terrifies anti-gun lawmakers. Make no mistake, Duncan versus Bonta isn't just a legal loss for California. It's a political earthquake. For decades, the gun control lobby has sold magazine bans as common sense reform. Politicians paraded the line that no one needs more than 10 rounds. Media outlets push the narrative that limiting capacity saves lives. But the Ninth Circuit's mandate ripped the mask off. By recognizing that millions of Americans own standard capacity magazines for lawful purposes, the court declared them common arms, and therefore protected by the Constitution. That legal classification terrifies anti-gun lawmakers because it doesn't just apply to magazines. It sets the stage for challenges to so-called assault weapon bans, too. If AR-15s and their standard magazines are in common use, then under Bruen and Heller, states cannot ban them. Period. That's why gun control groups are scrambling to spin Duncan as a radical decision. They know if this precedent spreads, it could dismantle decades of restrictions. And for politicians who built their careers on gun bans, that's not just a legal loss, it's an identity crisis. Chapter 9: What gun owners need to do now. So what does all this mean for you sitting at home with your Glock, your AR, or maybe just a simple home defense shotgun? It means 2 things. First, stay informed. Laws are shifting fast. What's unconstitutional today may still be enforced tomorrow until courts catch up. Know your state's rules. Don't assume that because California law seen, your state won't keep enforcing. Second, stay prepared. The Houston homeowner didn't have time to Google whether his magazines were compliant. He didn't have time to file a lawsuit. He had seconds. His preparedness saved his life. For every gun owner, that means training, situational awareness, and making sure your equipment is reliable and ready. Don't let a state house or courtroom dictate your ability to defend your family. And finally, support the organizations fighting these battles. Lawsuits like Duncan don't happen without groups like the California Rifle and Pistol Association, Firearms Policy Coalition, and Gun Owners of America. Whether you agree with everything they do or not, they're the ones keeping these fights alive in the courts. Chapter 10. The Future of the Second Amendment. So where does this all go from here? The answer: toward a national reckoning. With Duncan, Nguyen, and other recent rulings, courts are finally applying the Bruen test consistently. That means states can no longer pass laws just because they feel safer. They have to prove that restrictions align with the historical tradition of firearm regulation. And history isn't on their side. Expect to see more challenges in 2026 and beyond. Not just against magazine bans, but against so-called assault weapon bans, waiting periods, and even red flag laws. The Supreme Court may eventually be forced to address these head-on. And if Duncan is any preview, the tide is turning. The era of treating the Second Amendment as a second-class right is ending. This is more than just a California story. It's the beginning of a nationwide shift. From the courtroom battles to the real-world moments like that Houston homeowner who faced armed intruders pretending to be police. Magazine bans aren't about politics. They're about survival. And thanks to Duncan vs. Bonta, the law is finally starting to recognize that truth. Now here's what I want you to do. Share this video with your community. People need to know this ruling exists. Drop a comment. Do you think mag bans are finished? Or will states fight even harder to keep them alive? Because in this fight, knowledge is power. And together we're going to stay sharp, stay armed, and stay free. We'll see you in the next one.